Good day, Crime Talk aficionados. This is Crime Talk. My name is Scott Reich.
And I believe you have a filter turned on in the
Chad Daybell motion hearing that is set for this afternoon. The issue is regarding motions to compel regarding the expert witnesses that were supposedly going to testify at a motion for the change of venue, but the defense had not complied with the rules, and then there's been some recent filings as recently as today whereby Mr. Means is saying, hey, I'll turn this over, but you don't really need to know a bunch of this stuff, so we'll see. And I only had an opportunity to briefly glance at very poor sound. All right, let's see here. All right, we're fixing the sound. Not sure exactly what that is, but that's the one little thing we've always had an issue with the sound. I just do not know why. Anyway, so we're going to have a motion to compel regarding items that should have been turned over regarding expert witnesses that we're going to discuss why a change of venue is appropriate. Oh, we've got the attorneys on the Zoom call. Let's go to that now.
Good afternoon, Mr. Pryor, Mr. Means.
Good afternoon, Your Honor.
Good afternoon, Judge.
And Mr. Wood.
Good afternoon.
All right, this is the time we have scheduled on some motions on these cases. Before we start, there's a matter I need to discuss with counsel, Mr. Means and Mr. Wood. I'd like to just have a brief discussion off the record in a breakout room. So, Madam Clerk, if you could arrange for a breakout room, I'd invite Mr. Wood and Mr. Means to join. If you'll hold tight for a minute there, Mr. Pryor will come back on and commence with the hearings this afternoon.
So you, Mr. Wood, and Mr. Means, correct?
Yes.
Okay, just want to make sure I had the correct.
All right, so we are back, and as soon as they started, they immediately went into a breakout session, which in the old days would be when you went up to the bench, or maybe you went into chambers and talked about what the issue is, but you didn't want the rest of the world to know about it. So that's what a breakout session is these days. Sometimes they can resolve. Sometimes they can say, we've reached a resolution. There's no need to go forward. Or normally, there's just something you don't want the whole world to know as of right now. So that's what a breakout session is. And okay, and hopefully we're trying to fix the sound as we speak, because we were away for a whole week. Nobody was here to touch anything, and so not sure exactly what could have possibly been the issue. Still staticky is what people are saying, but I know there's a bit of a delay. Okay, that's fine. All right, we're going to change the cable right here. I'm going to unplug it here. Okay, now can you hear us? Is it better? Is it better? All right. Now can you hear it? That's the cable. We've unplugged the old cable and put in a new cable, although the new cable may be the old cable, which is so odd because, like I said, nobody was here all week to possibly touch or mess with anything. Unusual why that would break all of a sudden. And people are saying no better. All right. Well, here's what we're going to do. We're just going to wait for the breakout session. And I'm not going to talk. We'll just wait it out. Okay, I'm back. Is the sound better? Can you hear me now? How's the static now? Hopefully it's gone. Okay, we got a little bit of a delay. We're still waiting for the parties to come back. Okay, I think we're good. Okay, it was the cable, which is ironic because I think the now old cable was essentially a new cable, but now we have the old cable back in that worked just fine. But somebody said, you got to get the fancy cable, so we got the fancy cable. And look, it broke. Go figure. If it isn't broke, don't fix it. All right, so there's this motions hearing scheduled today, 3:30 Mountain Time in the great state of Idaho in the matter of Lori and Chad Daybell. The issue was supposed to be motions in limine regarding the motions hearing that was set for a change of venue. The defense had not turned over who had done their survey, what evidence was going to be presented, the curriculum vitae of the expert witness, and therefore the prosecution did what it was supposed to do, which was say, hey, limit this witness or witnesses from appearing. The defense filed some supplemental documents today in this particular case, and it just gets more and more ridiculous. Mark Means filed a couple of documents today. It was a brief in support of the state's motion in limine. Brief in support. State of Iowa. Oh, this is the brief that the prosecution filed, basically saying that the defendants had filed a change of venue, and that was ultimately set for a hearing. Both defendants have supplied limited discovery or documentation to support their motions. That the defendant, Chad Daybell, provided the state with the results of an, quote, informal survey, end quote, purportedly performed in August of 2020 in Fremont County, Madison County, and Bonneville County. Initially, defendant Daybell refused to provide the name of the individual performing the survey. Only after the state filed a motion to compel did the defense provide the name of the survey taker. That individual was never disclosed as an expert witness. And then on March 1st, 2021 disclosures, the defendant disclosed only the name of the individual who performed the poll, but provided no other data requested by the state as is required by the rules. No CV. The investigator's name hadn't been provided. I mean, it's been very limited and very somewhat sketchy. You have to just turn that stuff over. When anything that their expert relied upon has to be able to do that. And then John Pryor, on behalf of Chad Daybell, stated counsel for defendant hereby objects to the state's motion in limine to exclude a lay witness from testifying in the motion to change venue. The state has inaccurately described and identified the wrong rule for excluding a lay witness. We're going to talk about this in our show today, but a lay witness is somebody that, for example, doesn't have some sort of specialized training or knowledge, but it's still appropriate for them to give an opinion. The most common one would be a regular person. Have you ever observed a person that was intoxicated? Great. The person at issue in this particular case, did you have an encounter with them on the date in question? Yes, I did. Do you have an opinion as to whether they were sober or intoxicated? My opinion was they were intoxicated. That's a lay witness. A lay witness opinion. Could you estimate the value or could you estimate the speed of the vehicle that was traveling by? Was it more than 25 miles an hour? Less, maybe more than 55 miles an hour. That would be a lay opinion. The jury or the fact finder, the judge in a particular case, could decide based upon that particular evidence. And an expert witness is someone that usually has some specialized training or knowledge. Now, we're not talking about, expert witnesses, they have to have PhDs and master's degrees. No, it can be your auto mechanic that explain, hey, I've been a mechanic for cars. This car, basically, the issue, let's say the engine blew up prematurely. You can say that this engine is not the original engine. Anything along those lines where they can give an opinion, their expert opinion, that what they found is based upon their training and experience. But more often than not, expert witnesses usually have some sort of training or knowledge. And in this particular case, they have something, what's the word I'm looking for? Some skill, some training. I had an expert witness last week in a case. His job was to figure out why things broke. What happens to things when they break, so to speak. And, he rebuilds and redesigns things to figure out what happened as to why things went wrong. Now, the other motion that was filed today, and I don't get, it's declared motion, pursuant to the United States Constitution, Article 4, Section 1. Well, that sure sounds fancy, doesn't it? Oh, boy, it does. And it says, United States Constitution, Article 4, Section 1 states, full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. And the Congress may, by general law, prescribe the manner in which such acts, records, and proceedings shall be proved and effective thereof. And then there's some weird type, like maybe somebody forgot to change the type when they cut and paste on their motion. I guess it's maybe a footnote, but it didn't go down below. It says a common law marriage is valid when the couple cohabitates, they hold out each other as husband and wife, and there's agreement that they intend to be married. Under conflicts of law, the full faith and credit clause of the United States Constitution, states must recognize common law marriages when such marriage is valid in a sister state. But here, Mr. Means goes on and states that on November 5th of 2019, defendant Lori Noreen Ryan Vallow Daybell was legally and lawfully wedded to Mr. Chad Guy Daybell in the state of Hawaii. Defendant's true, spelled that wrong, should be the defendant's true full name as of this date, which precedes any legal action in the state of Idaho, is Lori Noreen Ryan Vallow Daybell, or Mrs. Daybell. And basically, he wants to have all the pleadings read Lori Noreen Ryan Vallow Daybell on the pleadings.
Yes, Rob.
All right, so we're back.
The judge would like me, Mr. Pryor, and the court reporter to go into the breakout room.
You,
I don't know.
the court reporter, and Mr. Pryor. Okay.
Yes.
In a new room, right?
Well, I think just the one that the judge and Mr. Means are in right now, if that's possible.
Okay. Oh, sure.
Okay.
Well, there you go. Another breakout session, but the district attorney apparently was trying to get entered into the room with the judge, Mr. Means, and Mr. Pryor. Not exactly sure what happened there, but needless to say, he is back. And apparently the court reporter is back there with them as well. Now, when it comes to these virtual court appearances, I will tell you, it has made my life
Mary.
so much simpler. What was that?
The lag.
Oh, okay. All right. There's a little break there. Looks like the court was trying to get somebody into the breakout room. But these virtual court proceedings, I'm telling you, it's the pandemic has moved the court system ahead by about a decade when it comes to technology over the last year, just simply because they're forced to do things over video to get things done. And it's actually pretty convenient in the sense that you don't have to drive everywhere. Obviously, for an attorney like myself that has a criminal practice, when you have to go to court, you got to drive. So you figure half an hour there, half an hour back each way, an hour, maybe 2 hours. Then you got to park, go through the metal detectors. And that is the one thing I swear I do not miss being an attorney that goes to court just about every day. Is I do not miss going through metal detectors, taking your belt off, emptying your pockets 3-4 times a day. When the people that work the machine know you, have seen you for years and years and years, and yet we go through this charade every day of taking everything out of your pockets, because maybe today is the day you're going to go crazy or something, I guess. I don't know. Anywho, so I don't miss that, but the virtual stuff has made it easier in the sense you do not have to drive around town, which makes it rather efficient in the sense that you actually get office time. It was very tough getting office time. Over the last year, I've spent more time in my office than I know what to do with, but I love it because I can get so much more stuff, legal work done. So I'm not looking forward to the point where we actually go back into court and have to wait, because normally you're never the only matter on the docket in the state court. Only time that happens is in federal court. When you show up in a state court, normally what happens is that you show up and there's 60 other matters on the docket that day. No one really has time to normally go over all the issues of the case. I'm not sure the Idaho East or the docket there in Idaho, but it seems like they never have anything else going on that they could just do that. All right, we're going back.
What we're trying to accomplish here
Is Mike still on? Okay, so the court apparently is having trouble getting everybody into a breakout room. And this started at 3:30, and it's now about 3:50. So it's been taking some 20 minutes to figure out the breakout room. You got to love technology for sure. Oh, they at least put the court is in a breakout room up on the screen, so I guess I'll be back. Like I said, there's good and bad regarding virtual courtrooms these days. Some of it is when the technology works great, it works great. When the technology doesn't work, it sucks, and that's normally what it amounts to. It just finally is starting to get where courts are figuring out, like, hey, we should stagger these court things, these court appearances, because before they would set, an 8:30 docket, you'd have 70 cases all set, and maybe you get through them by about 2 or 3, and then you still have the afternoon motions or something going on. Oh, and then the other, 4 days are used for trial that are taking place. The court finally figured out, usually through necessity, because they had certain bandwidth limitations, as I understand.
We're trying to get Doug's help from IT, Judge, and we've got my IT here too. There's something wrong with the breakout rooms.
Okay, if we need to log off and log back in or something, just let us know.
Judge, I hit breakout room and I joined Mr. Means, Mr. Wood, and the court reporter. If you hit breakout room and I hit it, we should all be in.
I think the real question here is,
perfect.
How many attorneys does it take to get into one breakout room? Apparently it takes 4 attorneys, IT from the state of Idaho, the court clerk, and maybe another IT person going in there. So I think we got at least 4 to 6 people for people to get into an IT room, into a breakout room because of IT issues. And like I said, this hearing started shortly after 3:30. 25 minutes has gone by and nothing has happened. So you just got to love it. Welcome to court. But if everyone was in court, they could have had this session and it'd be done. However, more than likely, then they still would not have it up for a virtual courtroom where we could view it live. We would just have to be able to get the report. I would much rather watch it live so I can see exactly what was said and make sure that we understand what was going on clearly. And hopefully, if there's any questions, I can try to explain that to you versus someone that hasn't been in the legal system. And I'm not saying you can't figure it out, but, it is a little more difficult than most people think. I was having this conversation with the lovely Miss Kristen just the other day because so many people think, well, I Googled it. Isn't that good enough? I Googled it. Well, there's lots of nuances. And I saw this thing the other day. It says, I want to be an attorney. Okay. What are you going to do to be an attorney? Well, you have to do what I did, which was years and years of practice, years and years of working late, reading the rules of evidence when you go home at night, reading the rules of criminal procedure, trying to stay up on case law that comes out on at least a weekly basis, if not a daily basis, practicing trials in your head, going over it, missing kids' vacations, kids' events, vacations, family vacations, because you have to work because you take care of everybody else's problems and usually don't have any time to take care of your own. That's why, just like here in this particular case, it sounds like they're pulling in the IT people. They're the experts. So yes, you can probably go represent yourself on a case where you can, maybe, something simple. And don't get me wrong, people do it all the time. I mean, look at Letitia Stauch. We all know she's going to represent herself. Somehow I don't think that's going to go well for her, but who knows? Maybe she will get lucky for sure. Let's see here. Please go over what you were reading about Lori and Chad's marriage. Yeah, that was some very odd motion that was filed by Chad, Mark Means, Lori Vallow's attorney, so that he could, what's the word I'm looking for? He basically wants her name to be referred to as Lori Noreen, where was it? Let me pull that up again. Wants her to be referred as Lori Noreen Ryan Vallow Daybell. Whew, isn't that a mouthful? Or Miss Lori Daybell. Giving full faith and credit to the United States Constitution, absolutely, right? If you're married in one state, you're married in another state. Apparently, normally you just say, hey, Judge, we would like to have all pleadings changed to a particular name. That's normally what takes place is somebody has a, for whatever reason, the police officers will misspell a name. They put 2 L's instead of 1 or, whatever. Usually it's misspellings. And you just say, hey, Judge, can you change the record? The correct spelling for my client is this. In this particular case, Mr. Means took the effort to fill this out to let everybody know that they were married on November 5th, and please refer to her as Lori Noreen Ryan Vallow Daybell. And apparently he's attached in the motion a complete copy of the certificate of marriage here from Hawaii, which I'm not really sure what the purpose is other than maybe trying to put somebody on notice of either A, it's just something simple like she wants people to refer to her by her new married name, or perhaps there's some sort of marital privilege claim coming up, and this is the precursor to it. I think it's more than likely she just wants everybody to refer to her as Lori Noreen Vallow Ryan Daybell. So yeah. And then the defense has also filed defendant's objection and response to motion to compel a motion in limine, where it says Mark Means through as counsel for defendant Lori Noreen Vallow Daybell files this amended motion to compel motion in limine brief in support of the state's motion in limine. Basically, go through the procedural thing, and that's how you write in the legal stuff. You kind of lay out the facts, what's taken place to date procedurally, what issue is going to be addressed in this particular pleading, the law that is applicable to that, the analysis, and then the conclusion. If anyone's ever had any legal writing course, it's referred to the IRAC method, issue, rule, analysis, conclusion, IRAC. But it should be facts, IRAC. Facts, IRAC, just a little thing. So anyway, it goes on in the motion. It says the state served supplemental discovery on or about February 23rd. The state filed their motion to compel February 25th. Discovery responses to this request were not due at that time, filing their motion to compel. If not denied, this request was seeking expert disclosure information, which is exactly what the prosecution was looking for. The defendant objected and says the state appears to attempt to hold the lay witness of the defense to the standard of an expert, but at the time argues said lay witnesses are not experts. The state cannot have it both ways. By arguing they are not experts, they cannot hold an expert disclosure standard, and the matter of testimony of a lay witness is a trial motion hearing issue. The argument on short notice of lack of expert disclosure but fails to qualify as expert is a house of cards which cannot stand as it takes inconsistent positions. Someone should read their motions before they file them because there's grammatical errors throughout. Furthermore, the prosecution is arguing facts, not in evidence. He refers to surveys, legal conclusions, expert conclusions, and if an expert or survey, etc. These arguments lack foundation and or consistency, and as such, denied with reservation for argument at the hearing. Then he goes on and says, I have not had time to adequately address a 14-page memorandum filed Saturday evening before this hearing. I will address the following. I will address as time allows the motion in limine. It doesn't seem, it definitely seems like this little response was written on the fly. But they're trying to say that their lay witness testimony is admissible if the testimony is truthful based upon the witness's personal knowledge and observation. However, they're going to issue a legal opinion, something that goes to legal issue in this case, then they need to be able to disclose that. And as you can see, we're not getting anywhere in this particular case because it took 25 minutes to do a breakout session, and they've been in their breakout session, which would normally be referred to as a bench conference or an in-chambers conversation prior to that. And so here we are. Hurry up and wait. Don't these people know that there are people out here that are waiting to see what is going to take place, and we are simply just waiting for the court to start this proceeding. And I'm not really sure what there could possibly be in regards to a breakout session at this point. You show up to a hearing. All right, let's address the matters on the record. There's these motions before the hearing. Why should this not be done on the record, in public? There is a right to a not only a speedy but a public trial, and the courts have said that they're trying to make it a public trial by viewing it out here on the internet. But if you're going to go into a breakout session when anything of substance is going on, you certainly would hate for the defendant to come back later if there's a conviction and say, hey, my family was denied a right to, you close this out. This should not have been a bench conference, and you denied my client a right to a public trial. Probably not so much an emotions hearing, but this kind of stuff should be limited to issues that are usually only before a jury. When you're in a motions hearing, there's no need to go up and have a bench conference. You do it all on the record anyway. I'm not exactly sure what they're doing or as to why they are doing that. I'm looking here at Phoebe Beach. Has the breakout session begun? Well, it looks like it started about 3:50 because it took about 6 people to get everybody in there to the breakout room. So they've only been in there about 10 minutes or so. So in that point, we wait. Let's see here. Yeah. We've used that term before, Black Widow, as it relates to Lori Vallow. I mean, maybe Chad Daybell thinks he's lucky, but I mean, my gosh, they're just dropping like flies when it comes to former husbands of Lori Vallow. And to be fair, natural causes, but you got to wonder. All right, so we got a super chat question. Could the name clarification be a pending proceeding? Wife and husband can't testify against one another. Well, interesting what you should say. Like I said, I took that motion as either A, the defense just simply wants her to be referred as a particular way in court and not as simply Miss Vallow. Refer to her as Daybell. Or it could be to set up a notice requirement that they were in fact married and that there may be some marital privilege. Now, normally, marital privilege only begins when you're actually married. In most states, even if there is a marital privilege, it doesn't mean it's an absolute privilege. Usually in cases of domestic violence, child abuse cases, you're not going to have a marital privilege, marital privilege is the kind of thing where you're laying in bed with your spouse and, hey, honey, what'd you do today? Well, you're not going to believe what I did. I robbed a bank. Okay? That would be marital privilege, assuming the people are in fact married. They're not going to bring the guy's wife in to testify or the other spouse in to say they confess to them. Marital privilege. But obviously, hey, what'd you do to little Johnny? Oh, man, I really kicked the crack out of it, and maybe I heard a bone crack or something. That way, the wife could still be forced to testify, or vice versa, the husband. But in child abuse cases, marital privilege normally does not apply. And common law, I'm not really sure the common law that they were trying to say. Are they trying to say that there was a common law privilege that existed beforehand? And, I don't do family law, thank God. But, most states, a lot of states don't have common law or vice versa, the husband. And normally you have to hold yourself out as husband and wife. You're each are holding yourself out as husband and wife. You just never want to do the formality of getting married. And at that point, you can say, oh yeah, we're common law married. But what most, and normally it has to be like 6-7 years. It's not talking like, oh yeah, I met this girl, man. We're like soulmates. We're married. That doesn't happen to be as a common law marriage. And usually all that gets you, if you're common law marriage, if you guys separate, guess what? You get to divide it up like you were married. You get to pay alimony like you were married. Congratulations, you made it. I'm not sure why you'd want to do that, so to speak. But so that's the question as to whether there's a privilege that is going to apply. Usually you have to assert the privilege, but that's something you would assert at trial. And then who has the privilege, right? Is it the person that said it, or is it the person that heard it that they're forcing to testify? Well, normally it's the person that says it has to claim it, and they have to prevent the other person from testifying to it. So lots of different scenarios we could sit and talk about all day. We just don't know. Maybe he just wanted to let everybody know that his client wants to be referred to as Mrs. Daybell. I guess that's what we'll just have to go with. But we'll see. These two it just goes on and on and on. I'm frankly a little surprised in the lack of movement in this particular case. It just seems like it keeps getting delayed on these discovery issues. Most of this stuff usually could be resolved. I don't understand why. It's a discovery issue. Set the matter on the docket. They set this stuff out weeks in advance, weeks forward. They should just be able to just do it rather quickly. I'm not sure why everybody needs to brief everything. Usually the party that's moving wants somebody to compel, to make them produce something. They're usually the ones that produce it, unless you have some great legal standing issue that you can do that for, to raise the objection. Usually just say, of course, like, Judge, I don't have it. I can't get it. I'm just not sure why it's taking so long. And even now, what are they doing in chambers? Somehow I find it hard to believe that everything that they're doing in this breakout session cannot be presented in an open courtroom. I can't imagine there's witness issues. They're not witness safety issues. That's normally the kind of situation where you go up to the bench and you say, Judge, my client's he's going to be a snitch, and I don't want the whole courtroom to know that, but that's part of his deal. We don't want that to be announced to everybody because, his safety's at issue. What's the issue here? I can't think of anything other than it sounds like, from the motions that we've seen thus far filed, is that maybe people are not prepared. I mean, it's very simple. If you want to have an expert witness, you have to endorse them in sufficient time. Normally it's 35 days prior to the hearing with the report of what they're going to testify to, what they're relying upon, and usually what is in that report is limited unless they're referencing a lot of these other documents. I had a trial last week, and I thought I was going to be held in contempt. Was moving to introduce some exhibits that were part of a much greater collection of documents that were not just actually in the particular report, but they were referenced. And the opposing counsel, the district attorney, comes to the judge, we haven't seen this. And I'm like, well, Judge, I turned it all over. Have the letter right here. FedExed it, in fact. Then the DA says, well, we just couldn't get it open. And I'm like, really, Judge? And my co-counsel, attorney in my office, is like thinking, calm down, calm down. I'm like, really, Judge? Really? They've had 8 months to review this, and they never called and said, oh, we can't get it open. And apparently they got open at counsel table, but they couldn't do anything with it before because they were just relying on that. I'm like, Judge, are you kidding me? If I had done that and not opened the supporting documents to report, the underlying supporting documents, I'd be contacting my malpractice carrier right now. Needless to say, DA wasn't impressed with that. But the gist of it is you got to turn over your expert stuff. In that particular case, we did. The other side just chose not to look at it. Here, the prosecution saying, hey, I want to look at it. I want to be prepared. I want to be ready to go so that I can, not waste the court's time. We'll see. I think what's going to take place is, we're coming back out perhaps, is that there's going to be another continuance, but let's wait and see.
All right, once everyone's back in the main session here, we are ready to get started. All right, I believe we have everyone now. Clerk, Madam Reporter, are you both ready?
Judge, this is Mary. I'm ready.
Thank you.
Yes, we're on, Judge.
Okay. We'll be on the record here. These are cases CR 222755, State of Idaho versus Chad Guy Daybell, and Fremont County case CR 2220-838, State versus Lori Vallow. Representing Mr. Daybell is Mr. Pryor. Mr. Means represents Mrs. Vallow. Mr. Wood represents the state in these cases. We have motions scheduled for today, including state's motions in limine, as well as a motion to compel. We also have scheduled a state's motion for remote testimony of a witness. In addition, we've got hearings scheduled on March 22nd relating to defendant's motions to change venue and a currently pending motion to dismiss. We had a discussion outside of the presence of the recording here. It was reported by the court reporter, and I'll note, due to the nature of the discussion, the reporting of that discussion will be sealed, but we did take a record of our discussions. After discussions with both counsel and in consideration of what's been presented to the court does find good cause at this time to vacate the currently scheduled hearings that are set for today, as well as vacating our hearings that are scheduled for March 22nd. The court will set a status conference, which we can use for further scheduling, on April 7th at 1:30. And counsel, that will be conducted by Zoom, as today's hearing was also conducted by Zoom pursuant to our Supreme Court's operating order. So that's all we're going to take up on the matter today. Mr. Wood, do you have anything further from the state to discuss this afternoon on the cases?
No, Your Honor.
All right, Mr. Pryor, anything further today?
Nothing further, Your Honor. Thank you.
Thank you. Mr. Means, anything else?
No, Your Honor. Thank you.
All right, thanks. That will conclude our matters for this afternoon then. Thanks for your attendance, everyone. Thanks for the assistance of the Supreme Court for your technical help in Fremont County. With nothing further on the docket, we'll go ahead and be in recess.
Well, hate to say I called it, but I guess I thought there'd be a continuance, and it sounds like there was, but they vacated today's motions hearing, and they also vacated the hearing that was set for March 22nd that was going to handle the motion in limine regarding the change of venue. What could that possibly mean? The court did say that their in-chamber hearing was going to be sealed so that obviously the recording was taken, but the court found good cause to vacate today's hearing, vacate the hearing on the 22nd, and basically schedule another date for April 7th, which is a scheduling conference. Now, what could that possibly mean? Let's face it, this case is getting a little long in the tooth, and you got a trial date coming up in July. It's going to be here sooner rather than later. What could it possibly mean? Now, here at Crime Talk, we don't like to speculate, but we can also tell you based upon our experience, and I think we normally get it right, just like I called it for today, that they were back there. Little unusual than the fact that they sealed it and the court finds good cause. What could it be? Could it be that there's maybe a proposed disposition in the works? Or could it mean that there is additional charges coming down the way? That's what that basically tells me. No one's saying, let's continue on, waiver of speedy trial. I think it's one of two extremes. Plea disposition, or there is some sort of additional charges coming down the way. Maybe that's what it's going to be. Maybe there's some, information that's going to be turned over and it's going to make all these motions for change of venue completely irrelevant. It just, we'll just have to wait and see. So I'm sorry that there wasn't an actual hearing today. We were kind of ready for it. We were ready for the other hearing on March 22nd that was going to be addressing the change of venue issue. Today was kind of hashing out those issues regarding witnesses, and that's all been vacated. The fact that the court sealed the hearing, the transcript of the proceedings that was held in chamber, makes me believe something big is going to be happening. And the fact that it's only set for a scheduling conference on April 7th, like I said, two extremes. Additional charges coming down, or something big, perhaps, or maybe there's a plea disposition in the works. Who knows? It's kind of like getting that jury verdict. We'll all find out together at the same time. So I won't keep you any longer. Thanks for watching. Check out our video that we put up today. Should be up shortly after Frank, the hardest working man in show business, gets that done, when he's done changing mic wires. And don't forget, tomorrow's Tuesday night. We'll have a regular show as well as our live and our Patreon show as well, where we'll be able to dig or be able to jump deeper into everything that's taking place in this case, the Lori Vallow, Chad Daybell matters, as well as other cases that interest you. So thanks for watching. Have a wonderful day, and we'll see you next time on Crime Talk.